इमेजिन करो तुम्हारा झगड़ा हुआ किसी से और झगड़े के बाद उस आदमी को धमकाते हुए तुमने व्हाट्सएप पे बहुत सारे धमकी वाले टेक्स्ट्स भेज दिए। अब क्वेश्चन ये है कि क्या इन टेक्स्ट्स को बेसिस बना के एफआईआर लॉन्च कराई जा सकती है, और अगर एफआईआर लॉन्च कराई जा सकती है तो इन व्हाट्सएप के मैसेजेस की एविडेंशियरी वैल्यू क्या होगी। Some time ago, a bench of Honorable Mr. Chief Justice N.V. Ramanna, Honorable Mr. Chief Justice A.S. Bopanna and Honorable Mr. Chief Justice Rishikesh Roy said, what is the evidentiary value of WhatsApp messages these days? सोशल मीडिया बहुत वॉलेटाइल है, कुछ भी क्रिएट किया जा सकता है, कुछ भी डिलीट किया जा सकता है। We cannot attach any value to the WhatsApp messages. This was an important statement made by the Supreme Court of India. पर क्या इसका ये मतलब है कि WhatsApp मैसेजेस की कोई वैल्यू है ही नहीं, वो एविडेंस के बतौर एडमिट किए ही नहीं जा सकते? Hang on, there is more to it than meets the eye. With the recent launch of 5G in India, we are once again set to explore the inevitable transition in favor of technology. Nothing today remains inaccessible by technology and social media. In this fast-changing world, it comes as a surprise that the relevance of technology is still minimal in the Indian law and judiciary. But every now and then, some interesting cases have had people questioning this limited involvement and extent of technology. Today, in this video, I shall address one highly asked question. Are WhatsApp texts admissible as evidence? अगर तुमने अपने दोस्त को धमकी भरे टेक्स्ट भेज दिए तो क्या तुम्हें जेल हो सकती है? October 2021, when Bollywood superstar Shah Rukh Khan's son Aryan Khan's case reignited a debate over whether WhatsApp chats or other forms of electronic communication are admissible evidence in a court of law. To answer this, first let's understand what actually is evidence. Evidence is a type of confirmation or proof introduced to instigate confidence in the matter. The legal meaning of the term evidence has been laid down in Section 3 of the Indian Evidence Act 1872. Section 3 defines evidence to mean and incorporate the following: all explanations which the court allows or needs to be made before it by witnesses concerning matters of truth under request. Such statements are called oral evidence. All documents, including electronic records delivered for the court's review, such documents are called documentary evidence. Simple भाषा में अगर A ने B का मर्डर किया तो वो सारे फैक्ट्स जो इस चीज़ को साबित कर दें कि हाँ A ने ही B का मर्डर किया था, वो एविडेंस कहलाएंगे। अगर वो फैक्ट्स ओरल फॉर्म में है तो वो ओरल एविडेंस है, अगर वो डॉक्यूमेंट्री फॉर्म में है तो वो डॉक्यूमेंट्री एविडेंस है। Coming back to the original question, let's take a look at what and when are WhatsApp chats or any other electronic record for that matter allowed as evidence. The basic rule of the Indian Evidence Act regarding admitting any electronic record as evidence is that it should be produced in the primary form of evidence, or the document must be proved by primary evidence. Absolute emphasis is given to the primary nature of evidence. Primary evidence basically evidence का original form है, तो अगर कोई डॉक्यूमेंट्री एविडेंस है तो वो प्राइमरी एविडेंस तब होगा जब वो ओरिजिनल डॉक्यूमेंट है। अगर तुम्हारा बर्थ सर्टिफिकेट एविडेंस के फॉर्म में प्रेजेंट किया जा रहा है तो प्राइमरी एविडेंस वो डॉक्यूमेंट होगा जो हॉस्पिटल ने तुम्हारे फादर मदर को इशू किया, ना कि उसकी फोटोकॉपी। In the year 2000, the legislature incorporated a special provision in the form of Section 65A of the Evidence Act, जो ये कहता है कि इलेक्ट्रॉनिक रिकॉर्ड को एज एविडेंस प्रेजेंट भी किया जा सकता है और प्रूव भी किया जा सकता है, लेकिन ये इलेक्ट्रॉनिक रिकॉर्ड सेक्शन 65B में दिए गए कंडीशंस को सेटिस्फाई करना चाहिए। इसको और थोड़ा सिंप्लीफाई कर देते हैं। Electronic record can be presented as an evidence and it can be proved also, provided that the evidence is in its primary form. वो इलेक्ट्रॉनिक रिकॉर्ड ओरिजिनल फॉर्म में होना चाहिए, उसका कोई भी सेकेंडरी फॉर्म नहीं चलेगा। अगर वो फोटोकॉपी में है या फिर कोई कॉपीड वर्जन है जो किसी पेन ड्राइव में है, वो एडमिसिबल नहीं है, वो अपने ओरिजिनल फॉर्म में होना चाहिए, तभी कोर्ट उसे एडमिट करेगा। लेकिन सेक्शन 65B कहता है कि इलेक्ट्रॉनिक रिकॉर्ड का सेकेंडरी नेचर भी हम एक्सेप्ट कर लेंगे, लेकिन जो 65B में दी गई कंडीशंस हैं फुलफिल होनी चाहिए। तो क्या है वो कंडीशन? There are basically 4 conditions described under section 65B clause 2 of the Indian Evidence Act to admit the secondary nature of electronic evidence as evidence in a court of law. The computer or the device from which the concerned information was produced must be used regularly over that period of time and by the person having lawful control over that computer. The concerned information during the said period was of such kind that it is regular and ordinary in such activity. The computer must be functioning properly during the concerned period and the information contained in the duplicate copy which is produced before the court must be the same as it is in the original electronic record. These are the conditions that one should fulfill if one is producing the certified copies of any electronic evidence in the secondary form in the Honorable Court as evidence. With WhatsApp's appreciable level of security and widespread popularity as a medium of everyday communication, let's shift our focus to the specific needs of producing WhatsApp messages as evidences. There are some conditions which should be satisfied for the admissibility of WhatsApp messages as evidence. The recipient should have received the messages, that is, in the context of WhatsApp double ticks. The telephone should be in regular use. It ought not to be damaged. The sender should have the intention to send those messages. Let's move our attention to some of the landmark cases with reference to the topic of our video. In Ambalal Sarabhai Enterprise Limited versus KS Infraspace LLP Limited and other, the Supreme Court has made reference to WhatsApp chats as evidence and said that the WhatsApp messages, which are virtual verbal communications, are a matter of evidence with regard to their meaning and its content to be proved during the trial by evidence in chief and cross-examination. In another case known as Girwar Singh versus CBI, electronic evidence was introduced before the court for which a committee was appointed to check the authenticity of the electronic evidence. Later, the committee found that the evidence wasn't the original one or the copy of the original. The evidence was copied numerous times on different devices and hence was declared to be inadmissible. Now let's have a look at the conclusion of this video. Despite the modern ubiquity of instant messaging and social media platforms, based on the discussions on point of law and the cases that are coming before the Honorable Supreme Court and several high courts, have reiterated on several occasions that WhatsApp chat will have no evidentiary value whatsoever if the same are not accompanied by a certificate under the section 65B of the Indian Evidence Act. Putting it in simple words, इलेक्ट्रॉनिक मीडिया एज एविडेंस प्रेजेंट किया जा सकता है, व्हाट्सएप के टेक्स्ट भी एविडेंस के फॉर्म में प्रेजेंट किए जा सकते हैं, प्रोवाइडेड सेक्शन 65B के कंडीशंस फुलफिल हो गए हों। सिंपल शब्दों में समझें तो कंक्लूजन ये है कि व्हाट्सएप के टेक्स्ट या सोशल मीडिया पे किया गया कोई भी डिस्कशन या कम्युनिकेशन एज एविडेंस एडमिसिबल है, प्रोवाइडेड वो अपने ओरिजिनल फॉर्म में हो, और अगर वो अपने ओरिजिनल फॉर्म में नहीं है तो सेकेंडरी फॉर्म में उसको एडमिट कराने के लिए कोर्ट में रिव्यू पे देने के लिए सेक्शन 65B इंडियन एविडेंस एक्ट की कंडीशंस फुलफिल होनी चाहिए, वरना वो एडमिसिबल नहीं होगा। In the year 2000, the Indian government specifically enacted the section 65A of Indian Evidence Act, which established certain criteria for the validity of secondary evidence before any court of law. The government also established the Information Technology Act in the year 2000, thereby demonstrating the legislature's favorable attitude toward the concept that according to the changing requirements and conditions of our world, legislation also needs to adapt.